Hey there, thanks so much for tuning into this webinar. We're going to take the next 30 minutes and talk to you about creating and protecting your legacy in a COVID world. My name is Brian Bogner. I've been doing this, I'm a financial planner. I've been doing this for over 20 years now. I own a firm here in the upstate of South Carolina called Parallel Financial, and I will be your host for this webinar today. Let me have Jordan, if you could introduce yourself.
Thanks, Brian. I'm Jordan Roberts. I'm an advisor here at Parallel. Been here since 2020, and I'm also a licensed attorney in South Carolina, and really enjoy digging into clients' financial plans and estate plans, and I feel like my background as an attorney gives me a unique perspective on that. So would really love to talk to you about your situation, so please stick around till the end.
Thanks, Brian. My name is Justin Hamrick. My firm is Hamrick Law, and we predominantly focus on estate planning, and great to be here with you.
All right. Well, as you can see, we've got a great team of folks here that know exactly what they're talking about, especially when it comes to estate planning. And we're here because the reality is we've just seen too many people not plan, and what it results in a lot of needless heartache, headache, money that didn't need to get spent. And so for the next 30 minutes, we're going to talk about how to avoid that. If there was ever a time to get your affairs in order, we believe that time is now. With this pandemic and what coronavirus, COVID-19 has done, I mean, just even here in the U.S., as we look at the number of cases, this was for last year, for 2020, or deaths, that this is really a time to get your affairs in order. Nobody has been immune to this, right? There have been lockdowns. So, I mean, whether you got infected with the disease or not, there have been lockdowns, there have been shutdowns. It's just, we've been having to quarantine. Our lives have been changed dramatically. And it's quite honestly led to a lot of isolation. I live 20 minutes from my father. He's 83 years old. He had to go to the hospital. Thankfully, it wasn't COVID related. But we couldn't go in. We couldn't be with him in the emergency room when he got admitted. He could only get one family member. They could only go for just 2 hours at a time. Important decisions were having to be made about his health, about other things, and we weren't there to all be surrounded. He wasn't able to be surrounded by his loved ones and the people that cared about him to help make those decisions. So now is the time to take action and prepare, okay? So that's what we're going to be talking about. I do want you to stay to the end, okay? Please, again, it's only a 30-minute webinar because we are going to cover COVID-19 updates to healthcare planning. We're going to cover the Secure Act. We've also got a giveaway. We got something that we're going to do specifically for you because every person's situation is unique. You'll be able to schedule a 30-minute session with us to just ask any question you want. There's the link. It's actually going to pop out here. You can click on it or put that in your browser and do that. And what I want to give you right now is in the question box, if you just type in toolbox and submit that, okay? We're going to email you 3 things. We're going to email you the Family Guide to Savvy Generational Planning, 6 tips for organizing your records, and 14 items to include in your will. So these are just some great resources. All you got to do is type in toolbox in that question screen. And at any time during this presentation, if you have a question, just type it in and we'll respond to you and answer your question there. So let's go ahead and get started. Jordan, tell us a little bit about if we don't plan, what can go wrong?
Well, I like to tell folks, someone is going to plan your estate. If it's not you, it will be the state. So it's going to be the politicians and legislators in your state who are passing laws that control intestate. So what happens when you die without a will? Those are the people that are going to be planning your estate if you don't do it. And probate is expensive. It's time consuming. It's something you want to avoid if you can. And if the benefit of having an estate plan is when you face incapacity or when you're nearing the end of your life, you have a plan in place. When you're in those situations, that is not a time where you're able to think with a clear mind and make decisions for how you want your assets and your treatment, your care at the end of your life to play out. The time to do it is really right now.
Estate planning it's not just about death. People seem to have that idea in mind, but most people don't just drop dead. Most people go through some period of incapacity before they pass away. And if you're incapacitated, you need someone to have the authority to be able to make both financial and healthcare decisions for you. So let's talk about financial and miscellaneous matters first. At the very least, you're going to need what's called a general power of attorney. It's a document that allows someone to take money out of your bank account to use for you, to file your tax returns, deal with your retirement plans, and do many other things for you. And if you don't have this document in place and your family needs to make these decisions for you, it's very likely they're going to have to go to court and get permission from a judge to be able to do that stuff for you. And that process, not only is it really expensive, it's also very time consuming. Now, many people already have a general power of attorney in place, and that's a really great thing. But there can be some drawbacks to relying solely on a general power of attorney for incapacity planning. The example I like to give is, let's say at some point your mind starts to go and you're giving money away to anyone who calls, schools, charities, churches, anyone who calls, you're giving money to. You still think you have it together, but the rest of your family realizes that you're not there. How do they stop you? Well, they've got to take you to court and get a probate court judge to basically strip you of your rights to that money. Again, expensive and time consuming. A general power of attorney is not going to help you in this situation. Now, what can help you is what's called a revocable or revocable trust. You can pronounce it however you like. I'm going to use the word revocable. Now, any type of trust, and there are many different types, but any type of trust is just a relationship among three parties. You have the creator, the trustee, and the beneficiary. The creator creates it, puts property into it, and the trustee is the person who manages that property for the beneficiary. Now, with a revocable trust, you serve in every role. You create it, you put your stuff in it, you as the trustee manage that property for yourself. So let's say this time you've planned with a revocable trust for incapacity. In your investment accounts, your other money, it's titled in the name of the trust. And again, you as the trustee are managing that for yourself. The trust says that if you are determined incapacitated, you are removed as the trustee and someone else steps in to manage it for you. So same example, you're giving money away left and right. Your family has you deemed incapacitated. And per the terms of the trust document, you are then removed as a trustee. The key point here is that the money's still in trust, but you're not a trustee anymore. And because you're not a trustee, you're not going to be able to touch that money. So it's much less likely that court's going to have to get involved in order to prevent you from spending that money down. And that's just one way that planning with a revocable trust can be better incapacity planning. Let's move on to healthcare stuff. At the very least, you need what's called a healthcare power of attorney. It's a document that allows a certain person to make healthcare decisions, choosing doctors, treatments, medications, and many other things. Now, it applies to both end of life decisions, like when you're on your deathbed, as well as before end of life, because you might not be in your deathbed, but you've got Alzheimer's or you're in a coma for 3 days, something like that. Your living will, that's just your instructions to the doctor about end of life. It's a document that's exclusively focused on end of life decisions. Final document I think people should have is called a HIPAA waiver. And through this document alone, these people cannot make decisions for you. They can just access your protected information, communicate with doctors, things like that. Now, many attorneys do not include a separate HIPAA waiver, but I think it's really important to have one. And this is why. Now, your healthcare power of attorney does have HIPAA language in it, but when you pass away, your healthcare power of attorney terminates. So if you happen to pass away from something like wrongful death, or it's related to medical malpractice, and your family needs to gather your protected information, well, they can't rely on your healthcare power of attorney anymore because it terminates when you pass. A HIPAA waiver can last for 2 years, up can last for 2 years after you pass away, and allow your family to gather that information. Now I'm going to turn it back over to Jordan to talk about long-term care.
So, according to a Morningstar study, 52% of people who are turning 65 this year will require long-term care at some point in their lives. So, what is long-term care? Well, you can kind of see down there at the bottom, there's some activities called ADLS, activities of daily living. And those are things like eating, bathing, dressing. If you can't perform 2 of those 6 activities, insurance companies are going to view you as eligible to receive payouts from their long-term care policy. Now, historically, what a lot of insurance companies and advisors would use were just traditional long-term care policies. Those policies have gotten very expensive, and so an alternative that we look at with some of our clients now are life insurance policies, so whole life policies with a long-term care rider. And the benefit of doing it that way is that you have a death benefit and you have some cash value in the whole life policy. And what you're doing is you're effectively bringing forward that death benefit in the event that you have a long-term care event. And so rather than having a traditional long-term care policy where if you don't use it, it's gone, with a whole life policy with a long-term care rider, you get some benefit from the policy even if you don't use it for long-term care.
Many people think that estate planning is just for the elderly, but that's not true. We don't know when you're going to pass. We don't know if you're going to become incapacitated. So that's why you should plan. Now stories seem to have the biggest impact, can have the biggest impact on motivating people to plan, because oftentimes it's not until someone's brother or your mom or a friend, they pass away, they become incapacitated, they don't have a plan in place, and they leave their family with a mess. And now you're thinking, well, I don't want that to happen to my family if that situation were to occur. So estate planning affects everyone. Years ago, had a case where single woman, I think she was about 30, she was involved in a car wreck, and as a result in a coma. Through her employer, she had a disability insurance policy in place, and her family wanted to trigger it to pay out in order to pay her various bills. But she had not done any planning, and her family had no documentation authorizing them to deal with the insurance company. So they had to go to court, spend a bunch of money just to get permission to trigger that policy to pay out. So stories have a big impact. And there's also a big misconception that spouses think they can do anything for the other spouse without any documentation. But that's not true. Let's move on to stage 2. I hope you're all having fun. Let's let the fun continue. The death rate is 100%. It's going to happen. It's going to happen to you one day. It's going to happen to me one day. But again, we don't know. So how are your assets going to be transferred to the people that you want to get them? You're either going to use a will or a revocable trust. So let's talk about playing with the will first. There's also a big misconception out there that a will allows you to avoid probate court, but that's not true. A will is just your instructions, your directions to probate court about who is to get your stuff. And in this context, probate court, it's a court supervised process where they oversee the transfer of the assets from you, the person who passed away, to the person or people who are supposed to get them. Now, there are exceptions. Assets that have a beneficiary form associated with them, like life insurance policies, retirement plans, annuities, those generally bypass probate court. But when you pass away, it's likely you're going to have at least some, if not many, assets that have to go through probate. So why do some people want to bypass probate court? One, the time involved. It's possible to do it in under a year, but I'd say on average, you're looking at least 12 to 15 months. Court fees. There are court fees that are based off the value of the property in probate court. And finally, privacy. Once your will is filed with probate court, it becomes public information. Some people are not concerned about that, but many people are. A stranger off the street can pull a copy of it and see what it says. Basically, you're on the court schedule. I mean, you're dealing with the government. So let's talk about how to bypass probate court, which many people want to do. Again, a revocable trust, this is the way to plan. You create it, you put property in it, you as the trustee manage it for yourself. Now, how exactly does it bypass probate court? The trust document names a successor trustee to step in at your death to take ownership of the property and distribute it based on what the trust terms say. Now, that's a little more of a technical explanation. I think a more simplified in layperson's terms explanation is this. Let's say you own a house and you pass away. It's got to go through probate court. Instead, if the house is in trust, even though you die, the trust doesn't really ever die. And many people find that explanation pretty helpful. Asset titling is very important in estate planning. And people tend to think that when I pass away, my house is just going to automatically go to my spouse. And that will happen if you own your house with a right of survivorship. But many people do not. Case I had a while back, husband and wife did not own their house that way. They had done no planning, no wills, nothing in place. Wife passed away, and wife had a son from a previous marriage. And as Jordan says, if you don't write your own plan, the state of South Carolina writes one for you. And what it says is, for any separate property you have, your spouse gets half of that, and your kids get the other half. So of wife's 1/2 interest in the house, husband got half of that, and her own son got the other half. So how the ownership ended up being is stepdad owned 3/4 of his own house, and stepson ended up owning the other quarter. And stepdad had to spend $50,000 to buy out stepson's 1/4 interest in his own house. So that's why we should plan. Let's go on to the final stage. How are you going to distribute your assets to your spouse, to your kids, to others? You're going to leave it to them either outright or in what's called a testamentary trust. So you pass away and you leave your stuff outright to your child or your spouse, whomever. Once they get it, it's more exposed to being taken from them through bad things that could happen to them. Divorce, bankruptcy, lawsuits. We can brainstorm all kinds of things. To avoid this, we can use what's called a testamentary trust. And what is that? It's just a trust that you create at your death for the benefit of someone else. For your child, for instance. So you create it at your death. Property goes into this bucket. Your child is the beneficiary. If you deem your child, if you think he or she is mature enough, old enough to manage that money, then you can allow them to be the sole trustee of their own trust. So let's go to two scenarios. Scenario one, you leave your stuff to your child outright. They get it. Car wrecks, divorce, whatever, it's more exposed to being taken from them. Instead, your documents at your death say that your assets are going to go into a testamentary trust for your child. They later get divorced. All kinds of bad things happen, potential bad things. But regardless, those assets are more protected. Now, the example I always like to use, I like to use my parents a lot. So let's say my parents, just to make it clear to you in case you're not quite tracking, let's say that my parents' plan says that when they pass away, I get my inheritance outright. So I get it outright, 8 years goes by, and my wife wants a divorce. Maybe she ends up taking a significant portion of my inheritance. Or I get it outright, us lawyers get sued. I've never been sued. I've got plenty of malpractice insurance. What if it's not enough? I've got great car insurance. What if I'm involved in some horrible car accident? What if it's not enough? So instead, the way I plan for my own parents is they pass away. Assets come to me in a testamentary trust. If I need to make mortgage payments, I, as the trustee, cut the check to the bank. If I need to pay for doctor bills, vacation expenses, I, as the trustee, cut the check to that third party. Then I later get divorced, sued, other things. The money and property that's still in trust is very protected. So let's recap the three stages. For incapacity, for financial and miscellaneous matters, you're going to use either a general power of attorney or a revocable trust. For healthcare decisions, healthcare matters, a healthcare power of attorney, living will, HIPAA waiver. For death, how are you going to transfer your assets? Through either a will or a revocable trust. And how are you going to leave your assets to your loved ones? Either outright or in a testamentary trust for them. And now I'll turn it back to Jordan.
You may remember back in December of 2019, the Secure Act was signed into law. And what that did is a number of things, but the highlights here are it actually raised the age when required minimum distributions. You may have heard that term thrown around. It's RMDs. But really what happens is at a certain age, the government requires you to start pulling assets from your retirement accounts. And so the Secure Act actually raised that age from 70 and a half to 72. And 72 used to be an important age because you had to stop contributing at that age to retirement plans. So if you had a 401k, you hit 72 and you're still working, you weren't allowed to continue contributing. Now there are no age restrictions on retirement plans. And then the last one, I think this one's probably the most important, especially because it requires specific knowledge of your situation and advice that's specific to you. But you may have heard the term stretch IRA. And what those are is if you inherited an IRA from a parent or other loved one, you used to be able to take those distributions from that account over your lifetime as the beneficiary. What the Secure Act did is it changed that and said now you have to take all the assets from that account over a period of 10 years. Now, it doesn't have to be even distributions through 10 years. So I'll give you an example. I had a client whose income at work fluctuated a good bit because he got bonuses. Sometimes he got bonuses, sometimes he didn't. And so what we did as we were working with him is in years when his income was high because of bonus, we scaled back that minimum distribution so that his tax burden wasn't higher than normal in that year. If he had a down year, maybe we take a little more from the retirement account in that year. And so this is where, for business owners, for people who have fluctuating income, it's really helpful to talk with an advisor so that you're able to maximize the benefits of these types of laws. Next, IRA tax strategies. So the environment that we're in right now, we're at historically low tax rates. And here at Parallel, we do not have a crystal ball. We can't predict where tax rates are going to go. But it's hard to see how they won't be higher in the future. And so the benefit of doing a Roth conversion right now is that you get to pay today's tax rates for money that you're going to take out and use later. So instead of paying that future tax rate, which will likely be higher, you pay today's tax rate. And then lastly, the other benefit of working with an advisor is that if you are charitably inclined and you are retired, when you want to make your gifts to charities, rather than take it out of your bank account and give it to the charity, what you can do is you can actually make a distribution directly from your retirement account. And so that's going to kill two birds with one stone because it's going to satisfy your required minimum distributions and it's also going to let you make those charitable gifts. And there are some great tax benefits there. And as always, these are individual specific, so they're specific to your tax situation. So please talk to someone like us before you decide to make a decision that has tax ramifications. And then finally, I'd also like to mention that the importance of having these types of documents digitized. So unfortunately, and I'm sure Justin could verify this too, is you'll run into clients who say, I named so-and-so in my will, I named so-and-so in my healthcare power of attorney. Well, did you tell them about it? Oh, no, I forgot to. And creates so many problems because you can't have people in these documents who don't know they're going to be called upon when you are incapacitated or sick. So go ahead, if you have a will or healthcare power of attorney, these other estate planning documents, and you haven't scanned them, now's the time to do that. And let the people know who have been named in these documents that they are in them.
All right. Thanks so much, Jordan. And I'll kind of close us out with some final thoughts here. But the important thing is you want to be organized. The more organized you are when bad things happen, the easier it will obviously be on you and your family. And just as Jordan was talking about, it's one thing to have all your documents in a file cabinet somewhere where you know where they are, but if your family doesn't know, it can be a huge problem. So it's not only about getting organized, but it's also about communicating, and we can certainly help you do that. But the most important thing I do want to leave you with is to do something. All right. And one of the things that we're offering that you can take advantage of right here, right now, is a 30-minute complimentary estate plan checkup. Okay. You can go to this link right here. It's www.calendly.com/estate check. And what that'll do is that'll take you to a calendar, and you can look for an opening time that you're available and schedule that 30-minute video. And it'll be a video call. And you can ask us anything, and we'll talk through with you and answer any questions, because everybody's situation is unique. All right. And what we have found, again, I've been doing this for over 20 years now, is for the best results, you want to surround yourself with a team of trusted advisors. And we're here to help you make the right decisions and help you do the right things, not only for you, but for your family and your loved ones. Justin, go ahead and close us out today with I know you've been just telling some very impactful stories, and I know you've got a good one here. Take it away.
So one last story to talk about. Husband and wife, years ago, they had wills in place, but they never signed their wills. And husband passed away thinking that he had a will, but you have to actually sign it. And it's got to be witnessed. It's got to be notarized for it to be valid. So husband went to the grave thinking he had a will, but he didn't. And in that case, there were many different issues going on. Probate took 3.5 years. So the point is, like Brian said, like Jordan's emphasized, just do something. It can be simple or it can be more complex, but just get something in place. And I'm going to turn it back to Brian for last items.
Yeah, here's our contact information. You've got Jordan, Justin, phone number. Here's our email address. If you've got any other further questions as well, again, you can just click on this link, and we will be able to give you any help and advice and set up that 30-minute call for us as well. And we'd love to talk to you about this. But thanks for tuning in. Thanks for listening today, and have a good rest of your day.